Honorable members, we will now proceed with the second reading of the Guyana Compliance Commission Bill 2023, Bill number 12 of 2023, published on the 20th of July 2023. Honorable Attorney General and Minister of Legal Affairs.
Thank you very much, Mr. Speaker. Mr. Speaker, Bill number 12 of 2023, Guyana Compliance Commission Bill 2023, is one of three bills that we are debating tonight that are central to the assessment that we will undergo in September. Mr. Speaker, Guyana has conducted two national risk assessments which have concluded in 2017 and 2021 respectively. In each of these risk assessments, it was noted that Guyana does not have adequate anti-money laundering, countering the financing of terrorism, combating the financing of proliferation of weapons of mass destruction, supervision for a number of reporting entities known as designated non-financial business and professions, abbreviated as DNFBPs. So that was a hole in our AML CFT architecture, that we don't have sufficient number of supervisory authorities to regulate various areas of activities in our financial sector. Under the Financial Action Task Force recommendations, it is imperative that these DNFBPs have a supervisory authority for AML CFT purpose. In small economies like in the Caribbean region, it is both onerous and impractical to create a supervisory authority for every area of commercial activity that falls under the AML CFT radar. The cost and bureaucracy that will arise in respect of the establishment of these supervisory authorities would be astronomical and not feasible having regard to the size of the particular financial activity. For example, pawnbrokeries. Still yet, there are many areas of economic activities for which there is no administrative structure within the public or private sector apparatus that can effectively act as and perform the functions of a supervisory authority for AML CFT purpose. For example, the auto dealer industry. Even further, Mr. Speaker, some entities have been assessed as higher risk vehicles for money laundering under both NRAs, for example, attorneys at law, accountants, and auditors. As I pointed out earlier, this dilemma is not unique to Guyana and pervades the entire Caribbean. In my capacity as chairman of Guyana's AML CFT National Coordination Committee, I instructed the members to provide a review of how other jurisdictions in the region have tackled this problem. What we found, Mr. Speaker, is that although some countries provide that associations for the legal and accounting professions can provide AML CFT oversight as self-regulatory bodies, however, AML CFT assessment of DNFBPS in many of those countries have indicated that the oversight provided by those professional associations is weak, thus resulting in weaker ratings for those countries. In Guyana's case, the Guyana Bar Association is simply not designed, lawfully empowered, and legally constituted to perform these functions in respect of lawyers, and clearly does not have the capacity to do so. For example, membership of the Guyana Bar Association is not even mandatory. So the Guyana Bar Association cannot be considered a viable option, at least not in its current constitution and composition. I will speak more about this a little later. Those countries that have used a financial intelligence unit or specifically constituted supervisory body have had better compliance with regard to these professions and sectors without their supervisory authorities, which are generally looked upon with concern by the FATF and other bodies who fight against money laundering and terrorism financing. This has been recognized and flagged by the Financial Action Task Force, the Caribbean Financial Action Task Force, and other regulatory international agencies supervising the fight against money laundering and terrorism globally and in this hemisphere. Additionally, Mr. Speaker, we have noticed that some virtual asset service providers, VASPs, have been looking at the Caribbean region to set up shop as regulation is weak. One only has to look at the situation in the Bahamas with Sam Bankman-Fried and FTX to show how this can have devastating financial consequences for persons investing in such a volatile mechanism. Based on these observations, the NCC has decided that it would be in Guyana's best interest to follow the precedent established in certain jurisdictions and to have a commission specifically tasked with the AML CFT supervision for unregulated reporting entities, as well as to restrict the operation of VSPS and eventually provide strict supervision and regulation of the use of virtual assets and operations of virtual asset service providers. This robust piece of legislation, Mr. Speaker, this is a robust piece of legislation, Mr. Speaker. It is recognized internationally that these reporting entities are subject to AML CFT regulations, despite various challenges by lawyers all over the world to AML CFT legislation, particularly as it relates to professional lawyer-client privilege. However, professional client privilege, it has been held, does not protect the commission of criminal conduct or furthering criminal enterprises. As a result, this lawyer-client privilege cannot be used as a guide for concealing information that may be qualified for monitoring under the AML CFT framework. In a judgment delivered by the Privy Council in the case of the Attorney General of Jamaica and the General Legal Counsel, the Attorney General of Jamaica and the General Legal Counsel against the Jamaica Bar Association, 2023 UK Privy Council, page 6. And let me explain, Mr. Speaker. The Attorney General of Jamaica and the General Legal Counsel was sued by the Guyana Bar Association. The Guyana Legal Counsel is a body that is equivalent to the Compliance Commission that we are establishing. The Bar Association took the Attorney General and the Compliance Commission in Jamaica to court because of the very thing that we are doing right now. And that's what I'm explaining now. It was held that both the inspection powers of the General Legal Counsel, that's like the Compliance Commission, a body similar to the one that this bill establishes, and the obligation to report suspicious transactions may involve some disclosure by attorneys at law of their clients' confidential information. The Privy Council ruled that this would be demonstrably justified and justifiable under the rule of law. Let me read that again. It was held that both the inspection powers of the General Legal Counsel, a body similar to the one that this bill establishes, and the obligations to report suspicious transactions may involve some disclosure by attorneys at law of their clients' confidential information. The Privy Council took the bull by the horn and recognizes that. And the Privy Council says, the Privy Council ruled that this would be demonstrably justified and justifiable under the rubric of the rule of law. The Privy Council further held that there can be no doubt that combating money laundering is of first importance to Jamaica, and that the extension of the regime to attorneys at law is rationally connected to that objective and is not arbitrary. Finally, the Privy Council confirmed that the obligation imposed upon attorneys at law to report suspicious transaction does not interfere with legal professional privilege. There are therefore sufficient safeguard against mistaken disclosures, as attorneys can seek advice from specialist attorneys if they are unsure whether to make a report. So, Mr. Speaker, the issue of lawyer-client privilege has been interrogated extensively, beginning at the High Court of Jamaica, the Court of Appeal of Jamaica, and concluded at the Privy Council. This case started several years ago. The entire Caribbean put their AML CFT compliance agenda on hold to await the determination of this issue, because lawyers throughout the Caribbean had raised objections. Now that the Privy Council has pronounced conclusively and finally on the issue, moves are now afoot across the Caribbean to correct the deficiencies, as we are doing now. Mr. Speaker, I may get the criticism again that this bill was not widely circulated. Apparently, the dilemma here is that if members on the other side do not read the bill or not aware of the bill, and that due to their own default, the bill is not circulated. That is the inference I'm drawing. That's the inference that I'm drawing. Once they don't know about it, then it doesn't exist. They only know about it when it's fixed for hearing, when it's fixed for debate. Then they become alive. Then they wake up from whatever slumber they're in. So, Mr. Speaker, a draft of this bill was publicly circulated at the beginning of May 2023. It was posted on the website of the Ministry of Legal Affairs, and a public notification was issued to that effect, inviting inputs. News stories of this bill, based upon that publication, was widely carried in the press in Guyana. Additionally, copies of the bill were sent directly to the Guyana Bar Association, the Berbice Bar Association, the Institute of Chartered Accountants of Guyana, the Private Sector Commission, and the Georgetown Chamber of Commerce. The bill impacts significantly on two professions in the country. And from the get-go, they were directly sent a copy of the bill, and their engagement was invited. Their input was invited. Yesterday late, I received a letter from the president of the Guyana Bar Association, belatedly expressing concerns and raising certain objections to the bill. Although receiving the letter only yesterday and yesterday afternoon, out of deference, the concerns expressed were examined until 1 o'clock this morning. And having regard to the ruling handed down by the Privy Council, I am of the considered view that the concerns raised are without merit. When the Privy Council handed down this decision, and I have it here, and you can see, sir, it's quite an extensive judgment. The Privy Council they don't normally give such voluminous judgment, but on this occasion, they perhaps felt compelled to do so. So I examined the concerns of the Bar Association. I was aware of them long before. It is what kept the Bar Association outside of the legal regulatory framework. As the Minister of Finance is reminding me, it's not a new nor novel issue. And it is not an issue peculiar or unique to Guyana. I must observe that many jurisdictions in the region left the legal profession without a supervisory authority while they awaited the outcome of this legal challenge, which lasted several years. This year the case has been decided, and it has conclusively and comprehensively settled the issue. Guyana is simply following the rest of the Caribbean in bringing the legal profession within the AML-CFT regulatory framework. In fact, the only countries in this region under CFATF regulation that are without supervisory authority for the legal profession so far are Guyana, Haiti, and Venezuela. All the rest of the Caribbean gone already. This Privy Council judgment was handed down since November 2022. All of them have complied. And the legal profession in the entire region are now within the framework of the AML-CFT. Here are the countries: Guyana, Haiti, and Venezuela. Venezuela is an international pariah in the AML-CFT world. I don't know where Haiti stands. Guyana is not in illustrious company here. This bill will now extricate Guyana from this list. In light of Guyana's impending mutual assessment scheduled to take place in September 2023, our government is not prepared to expose Guyana's entire fiscal framework because the legal profession objects to being regulated by a framework that regulates every other area of economic activity in the country. In any event, Clause 64 of the bill provides for the Commission to issue guidelines or codes of practice for reporting entity under its supervision. The legal profession and every other reporting entity are free to consult with the Commission in fashioning guidelines that would be mutually acceptable. So the door is not completely shut here for both the Bar Association and the Accounting Association. So the accountants called me last night, or a representative of theirs. And they asked why their body can't be used. And the arguments that I have set out here, I explained. I also said to them that you will do your regulatory framework. You will do your own monitoring and supervisory. We are not taking away your role. But this is the formal body connected with the AML-CFT legal architecture of Guyana that will have to eventually be the receptacle of the records. And you will have to maybe comply with additional guidelines. Were the Guyana Bar Association in a similar construct and equally endowed as that association is, the same could have applied. But you know, Mr. Ramjatan, you said it earlier tonight, that it is self-regulatory, it's almost ad hoc. It doesn't have mandatory membership. I don't think you're a member. Financial, that is. So you pay only when elections come around. And as I pause here, Mr. Ramjatan, you said something that I should have addressed, and let me address it now. The Real Estate Authority has nothing and does not in any form or fashion detract from the Guyana Revenue Authority performing its taxation or tax collection functions. How can you as a lawyer believe that the establishment of that authority could undermine the GRA? I don't understand. Because it is incapable of understanding. Authorities are created across the laws of this country. Every bill we bring here would have an authority in it. Do they detract from the GRA? What kind of reasoning is that? The GRA is created by the GRA Act. It has a stipulated functions. It is the exclusive tax collection agency of the state. How any other statutory agency can compete with that? Mr. Speaker, the bill part 2 provides for the establishment and functions and powers of the commission. And I've said a lot about the commission. The bill establishes the commission, while clause 4 outlines its functions, which also involves the conduct of on-site and off-site inspections, as well as having the requisite powers of a supervisory authority as enshrined in the Anti-Money Laundering, Countering the Financing of Terrorism Act. So, in essence, in a nutshell, what we are doing here is the AML-CFT has a structure. You have reporting entities. They deal directly with the transactions, and when a suspicious transaction arises, they are to report. So you have to have an agency to which they can report. That agency is called a supervisory authority. Then that supervisory authority relates directly to the FIU. Or the structure can go higher depending upon the particular area of the economy that you're dealing with. The banks, for example, have a far more complicated structure all the way to the central bank, and that is the supervisory authority, and they relate directly to the FIU. So there are many agencies, because our economies are small in the Caribbean, that you can't create supervisory authorities for. It's not possible. The activities sometimes are too small for each activity to have a supervisory authority to monitor it. The bureaucracy is onerous, is cumbersome, is costly. So what has been done in the region is that you set up one body, you call it a compliance commission. It goes under different names in the region. In Jamaica, as you saw it just now, it's called the Legal Council, the General Legal Council of Jamaica. And that body is comprised of trained professionals in the area of anti-money laundering, and they supervise a variety of reporting entities that do not have a supervisory authority. As I said in another forum, is the parents for all the orphan children in the AML-CFT structure. So that is what it does, and it has to perform those functions. Clause 5 of the bill gives the Commission the power to delegate certain functions, but specific powers are not possible to delegate, such as licensing or sanctioning powers in relation to license, suspensions, or revocations. License powers are never delegatable. Part 3 of the bill deals with the requisite administrative aspects of the board of the Commission. Clause 6 of the bill provides for the composition of the Commission, which shall consist of 5 persons appointed by the Minister of Finance, who appear to him to be qualified and experienced in matters relating to commerce, economics, real estate, insurance, pensions, securities, credit unions, law, accounting, or such other areas in his opinion are required for the management of the Commission. Dr. Singh, you may come under fire here, because once they see a minister appointing, we are entering into devil's territory. Unfortunately, like I alerted them, they didn't know that. They didn't read that. Part 6 deals with registration and sets out the powers of the Commission. These include that the Commission can cancel, suspend, or revoke a registration and recommend the revocation of a license or membership of a professional body. It would therefore be an offense not to become registered and to perform functions listed in the first schedule if unregistered. Clause 53 mandates reporting entities to provide their beneficial ownership information to the Commission and ensure that it is current and legally updated. It also allows the Commission to effect its functions under the AML-CFT Act, with regard to fit and proper criteria for directors of reporting entities if those reporting entities are companies. There is also a power to disqualify directors and officers of companies who do not meet the fit and proper criteria in the third schedule. The Commission has powers of entry, inspection, etc. These are all powers that supervisory authorities have under the substantive law, this principal AML CFT legislation. All we are doing is that we are creating this unique, generic supervisory authority. So we have to bring over all the powers that supervisory authorities already have. Honorable Member Ramjitan, not new powers, don't get excited. They are there, they were there since 2010. We are putting them now into this commission because it will now have to perform the same functions that those bodies are performing. I see you got all excited that you hear powers. The commission has, yeah, you look exciting. The commission has the power to require the production of records, the power to demand records, and all the powers of the AML CFT bill. What the thing has under the Principal Act. I don't think it's necessary for me to go through them. This Parliament is very experienced in relation to AML CFT legislation. So what the bill does, as I said, is to import from the principal AML CFT Act all the powers that a supervisory authority would have and empower this commission with it. And this commission, as I said, will be the umbrella compliance body for all those agencies that do not have a proper supervisory authority, like pawnbrokery, that's what I mentioned, auto dealership, big industry, but how do you supervise auto dealer? We have been using, for example, the GRA, but there is no functional relationship between the GRA and the auto dealer other than a tax relationship. Other than a tax relationship, there is none. GRA has also been supervising a number of agencies over which they really don't have the type of control and relationship with to exercise the type of powers that the supervisory authorities have to exercise. The GRA can't ask the auto dealer for books that are not tax related. AML CFT deals with transactions that go beyond taxation. So we can, the GRA performs a completely different function. I don't know how to cleanse your minds from this unfounded, unhealthy suspicion. This thing is a state agency. This is not a government body, a national compliance. That is a state agency too, but that has to collect tax. That has nothing to do with money laundering. The money laundering is a different structure, Mr. Speaker. There's only so much I can do. The English language is limited, and so am I, Mr. Speaker. I can't explain clearer than I have done. So, Mr. Speaker, I ask that the bill be ready second time. Thank you.